Nicholson, and I represent the defendant Boykin Miami Hotel LP and Boykin Management Company LLC in Arlene Valdez Castillo versus Busch Entertainment Corp., DBA Busch Gardens Tampa Bay, Boykin Miami Hotel LP and Boykin Management Company LLC, Conservation Ambassadors Inc., formerly known as Zoo2U Wildlife Education Inc., formerly known as Wildlife Education Inc., formerly known as Wild on Wheels Inc. The facts of this case are as follows. In February of 2004, representatives of Busch Gardens and Wildlife on Wheels Inc., hereinafter referred to as WOW, stayed overnight as guests at the Hampton Inn and kept with them certain wild zoo animals in their hotel rooms, including monkeys, reptiles, and birds, hereinafter referred to as zoo animals. The plaintiff, Arlene Valdez Castillo, hereinafter referred to as Valdez, was at all times material a housekeeper at the Hampton Inn. While cleaning the rooms of the handlers and the zoo animals, Valdez claims that she came into contact with dander, feces, urine, excrement, and odor, following which she developed various physical and emotional problems, including severe, painful, and debilitating skin lesions about her torso, extremities, and face, fatigue, headaches, depression, as well as having developed a new allergic reaction when exposed to certain other animals which did not exist prior to the alleged incident. Plaintiff Valdez alleged the defendant Boykin Miami Hotel and Boykin Management Company LLC, hereinafter referred to as Hotel, were negligent in their duty to safeguard her as an employee from known hazards. The legal issue at defense today is the hotel defendant has a duty to safeguard its employees from known hazards. Both the risks of animal waste and the susceptibility of the plaintiff to a severe allergic reaction were unknown to the hotel, so they have no liability for the plaintiff's alleged injuries. The hotel applied safe cleaning practices, which are the standard in the hotel industry, and no special hazards were known to the hotel. The first offense is that the hotel cannot be held responsible for the actions of third parties not under its control. There is no breach on behalf of the hotel that is the proximate cause of the damages alleged by the plaintiff. According to our textbook, proximate cause is a limit on legal liability. It is a policy decision that the defendant's conduct and the plaintiff's injury may be too remote for the law to allow recovery. It is well settled that there can be no proximate cause where there has intervened between the acts of the defendants and the injury an independent act of a third party which was not foreseeable to the defendants, which was not triggered by the defendant's acts, and which is sufficient of itself to cause the injury. Basically, the hotel cannot be held liable of the condition created by a third party, in this case Busch Gardens and WOW, the condition of the room, and the damages that were suffered by the plaintiff. The second defense would be that the hotel was not notified by Busch Gardens and WOW that a dangerous condition existed in the room, therefore was not afforded time to repair or cure the condition and eliminate the risk of injury. In its affirmative defenses, the hotel asserts that the plaintiff had the same or superior knowledge as to the alleged danger or defect as the hotel did and failed to mitigate her damages. The plaintiff had knowledge that she had a pre-existing condition that could be aggravated by exposure to the zoo animals and their dander, odor, feces, urine, and excrement, and failed to notify her employer to make reasonable accommodation or take the necessary precautions to complete her task in the scope of her employment, i.e. cleaning the room. Her negligence is a superseding occurrence and breaks the chain of causation between the defendant's alleged negligence and the plaintiff's injury. The plaintiff's actions constitute contributory negligence, wherein the plaintiff contributed to her own injury by entering the room and exposing herself to a condition that would aggravate her pre-existing condition, as alleged in plaintiff's first amended complaint, paragraph 33. She did this for the duration of the zoo animal's stay at the hotel. A person of reasonable prudence with prior knowledge of a pre-existing medical condition would not act as carelessly and negligently in exposing themselves to any agents that might aggravate said condition. Any recovery by the plaintiff should be reduced to reflect the comparative negligence. In essence, the hotel did not have any liability in this matter. They cannot be held responsible for the actions of third parties. As a result, the plaintiff should not be awarded any recovery from the hotel, Boykin Management, and Boykin Miami. Thank you.